Welcome everyone to the week 7 lecture video, and the topic this time will be about assessment of damages for personal injuries. In the past 6 weeks, we've covered the elements of tortious negligence that has to be proven in order to allow a plaintiff to succeed in his or her claim in an action on tort based on the commission of a negligent action or omission on the part of the defendant. Of course, it's one thing to talk about an action being successful on the basis of the commission of tort, but ultimately the question is, how much would the damages amount to? How much is a plaintiff likely going to be able to recover? So from the viewpoint of the plaintiff, he or she would be interested in knowing, how much money will I be receiving? From the viewpoint of the defendant, on the other hand, the defendant would be interested in knowing how much money would I have to shell out. These types of questions, these practical questions, are important because, as you will learn when you eventually practice law or when you examine issues about litigation and legal action, you will know that in Australia, a lot of these litigation or legal matters are actually settled out of court in the form either of negotiations or through other alternative dispute resolution mechanisms such as mediation or even conciliation. And so that would mean that for the parties involved in a legal matter or for the solicitors involved in a legal matter, they need to know the prospects of success when an action on the basis of tort is being filed and how much the damages will be. Now, when we examine the topic of assessment of damages for personal injuries, and when you go through the textbook, it can appear that the topic is really dry. It's pretty boring. But in fact, it is a very important topic because when you think about it, it's all about showing me the money. So as Tom Cruise would say, show me the money. And now that particular topic, this particular topic, therefore, is in fact pretty relevant to lawyers and solicitors. We recall when I first talked about torts in my week 1 video, which happened some months ago, about almost 2 months ago, I mentioned that much of the litigation or potential litigation happening in Australia actually relates to tort law. And as I mentioned as well, when you go around various parts of Australia, you will often see billboards and other forms of advertising where law firms would say, no win, no fee. Where an arrangement whereby, if there were a car accident or if there were a workplace injury, the law firm would be willing to accept your legal matter and represent you, and you don't have to pay anything. You will only have to pay if the action becomes successful. It becomes successful either because there's an award for damages in court or because there is a settlement that is reached, for example, with a defendant. So there would be at least three parties which are very interested in the issue about show me the money. One is the law firms, because if a law firm is prepared to say is prepared to undertake a legal representation on the part of the client under a no win, no fee arrangement, the law firm has to be sure that not only would the prospects for success be high when an action for tort is commenced, but also that there is a certain amount of money that would be sufficient to pay the law firm for any expenses or costs it may incur in the process of moving the legal matter towards the courts. So what you will probably know is that for a lot of these law firms, they would typically hire a medical expert in order to assess the potential injuries and the costs of rehabilitation on the part, for example, of a person who has been injured in a tortuous incident. They may even hire barristers if it comes to the point where the matter has to be filed in court, and there might be a trial. So it can be very expensive on the part of the law firm. So for the law firm has to know, is this a particular legal matter that the client, that the law firm should represent, given the financial investment that law firms typically have to advance on behalf of the client. In addition, and that's important to know, because it's one thing to say that it could be proven that a defendant is liable for the tort of negligence. It's one thing for that to be established, but it's altogether different to ask the question, how much is the likely amount of damages to be recovered by a plaintiff? That is a crucial point, because you may end up having the same kind and nature of tortuous incidents, such as a motor vehicle accident. So you might have a motor vehicle accident, exactly similar. You might have two different plaintiffs, on different situations where somebody becomes, as a result of the accident, a plaintiff, for example, may become a quadriplegic and become paralyzed as a result of the accident. But at the end of the day, what matters as well is, who was the plaintiff? Because there is a huge difference between a plaintiff, for example, who is unemployed, and a plaintiff who is employed and earning a lot of money. Because the loss of earnings, for example, is a major factor that has to be considered when it comes to the amount of damages that can potentially be recovered when there is an action for tort on the basis of personal injuries that have been suffered. So that is a very relevant question for the law firms. They want to know who is the plaintiff. How much are we likely able to recover? Now, from the viewpoint of the plaintiff as well, of course, the plaintiff would like to know, if we commence this legal proceeding, and assuming even that the law firm is able to advance the costs prior to litigation or prior to trial, that will entail some kind of a lot of stresses on the part of the plaintiff in having to think about the possibility of trial. And so for the plaintiff, he'll be asking, sure, this might succeed, but how much will I recover? Because of the amount of recovery involved will be very little, because you might have a situation where the employee, because the plaintiff might be unemployed, then for the plaintiff, there might not be any point in filing an action for tort. From the viewpoint of the defendant as well, there will often be negotiations prior to court litigation, among the lawyers or between the parties, and the defendant would also like to know, how much will I have to shell out? What kind of damages am I likely to have to be liable if there is a finding by a court that a defendant is liable for the tort of negligence? So these are some of the questions on the part of the defendant. The defendant too may be asking, if I am ordered by a court to pay at a certain point, what if the plaintiff suffers complications? Will I be liable for damages, for additional damages as well? And this was one question that I encountered when I advised a client some weeks back. And we will encounter the principle known as once and forever in tort law in this particular lecture video. This is also a relevant question, because although we know that a lot of people in Australia, especially those who are driving motor vehicles, for example, we do know that for a lot of them there's comprehensive insurance, or there might even be third-party insurance, so that even if a plaintiff were liable for a motor vehicle accident and there was tort involved on the part of the defendant, then potentially it will be the insurance company that will have to pay for the damages. However, only last month I actually ended up advising two separate clients, and they were all less than 20 years old in age. But although there was insurance coverage for their vehicles, or even for damage to a third party, the problem was they were both drunk at the time of the motor vehicle accident. And for a lot of you may know that it's quite common in insurance policies that the provision pertaining to coverage by an insurance company is invalidated in the event that a defendant driver is actually drunk behind the wheel. So that becomes an issue. In this particular video as well, we're going to encounter a particular story where a friend of mine was involved in a workplace accident. So while he was, while he was in the factory, there was another individual who was trying to move around a few things, and one of these major crates actually fell on him, and it pinned him to the ground, and he suffered catastrophic, injuries. And although my friend was eventually able to recover after undergoing surgery and after being in hospital for quite some time, he was able to recover. You may be interested in knowing why was it that my friend tried to fake his sickness, so that for the next 2 or almost 3 years, he actually stayed at home pretending that he was severely depressed. What was his reason for doing that? You might also have encountered incidents where a defendant would try to fake his injury, saying, there's a whiplash injury and I've hurt my neck. And in fact, they're just faking it. What's the reason for that? And a lot of it has to go to issues about assessment of damages. You might also encounter a situation where this was in relation to when I was talking to a solicitor friend of mine, and the wife was saying, would it be possible, for her to try to crash the car, so that after she crashed the car, they would then collect on the insurance in relation to the husband, who would then become the plaintiff, even though it was the wife who would have been, the nominal defendant, because she would have been guilty, for example, of negligent driving. And how does that work? And the reason for that is that in a lot of these negligence claims, it is in fact possible for that scenario to happen, because eventually it's going to be the insurance company anyway who will end up paying for damages. So again, this is a real relevant issue, and there will often be a lot of ethical questions involved. In the US as well, you might know that there have been multi-billion-dollar settlement agreements in relation to tobacco cases, cases as well where a tortious liability is so egregious that juries often award multi-million-dollar punitive damages. We will encounter in this particular lecture video that the scope for awards of punitive damages is very limited. We will also know that in this lecture video that there are limits that have been set by statutory intervention in practically all the states in relation to the amount of damages that can be claimed for personal injuries. So, having said that, at the end of this module, you should be able to describe the different types of damages available in tort, explain the common law principles governing the award of damages in appropriate cases, explain how heads of damages are used to calculate an award of damages and apply to specific fact scenarios, and discuss the impact of the Civil Liability Act 2003 Queensland on the award of damages for personal injuries. Now, so let's begin. Although, as we said, much of tort law is actually based on the common law, in other words, it's based on decisions by judges, we now know that state parliaments have actually intervened to modify judgments made by the courts, so that in all jurisdictions in Australia, the Civil Liability or Civil Wrongs Act of other jurisdictions place limits and or ceilings on the recovery of damages for pecuniary losses. So this kind of scenario is really different, because if you go to the US, where there's a lot of tort litigation, there's almost no limit to the or ceiling to the amount of damages that could be recovered in relation to pecuniary losses. But in Australia, though, there has been state parliamentary intervention, So there are now limits and ceilings on the recovery of damages for pecuniary losses. As well, in all jurisdictions except the Australian Capital Territory, the Civil Liability or Wrongs Acts of other states prescribe the figure to be used for discounting future losses to present value. So there's almost a formula that courts can use or that lawyers can use in trying to determine, how much is intended to be awarded to a plaintiff who can be successful in an action in tort. And these kinds of figures enable an overall assessment of the monetary damages that ought to be awarded to a plaintiff. In addition, in all jurisdictions, the Civil Liability or Wrongs Acts place limits and or ceilings on the recovery of damages for non-pecuniary losses. So when we will learn in this video that when we talk of non-pecuniary losses, this can include, loss of amenities, loss of, because somebody may have lost a limb or has become paralyzed, and so therefore there are certain comforts and conveniences that an ordinary person has, which potentially would have been lost as a result of certain injuries. There would be limits to the amount of recovery that could be made, as well as for pain and suffering. Again, in the US, there's hardly any limit or ceiling in relation to damages that could be recovered for non-pecuniary losses. Okay, now one of the most important principles in tort law is actually the once and forever principle. But before we get there, let's first talk about what the purpose is for an award on the basis of tort. So as a rule, if a plaintiff persuades the court on a balance of probabilities that her or her injuries were caused by the defendant's negligence, the court orders the defendant to compensate the plaintiff by payment of a sum of money known as damages. So the compensation is in the form of a sum of money that is paid to the plaintiff, and these are in law called damages. In Todorovic versus Waller, the High Court had said, and this is very important, that if the plaintiff is successful, he should be awarded a sum of money as will, as nearly as possible, put her or him in the same position as if she or he had not sustained injury. So there is an attempt, one of the major functions of the payment of damages is to try to bring the plaintiff to a situation where he would have been if he had not sustained this injury. So as much as possible, that's what the award of damages is intended to do. And as important, damages must be recovered once and for all as a lump sum. Although we can see later on that it's possible for the parties to agree that it doesn't have to be a lump sum. But as a rule, if a court makes a finding that a plaintiff should be awarded damages, the damages are to be paid in a lump sum, and there is the element of the once and forever principle, so that once a payment has been made or damages have been awarded in a tortuous action, the defendant is no longer in a position to further recover from the plaintiff for the same injuries, even if there might be complications. So that's the end. Once damages have been recovered, that's the end of the legal action over that legal matter. And once the damages have been awarded, it doesn't concern the court how the plaintiff uses the sum that is awarded to him. So, for example, if in computing the amount of damages, part of the computation was based on an assumption that a plaintiff is injured is likely to be taken care of in a hospital or in a private care institution, and these are the costs, which might say be, for example, $300 a day, and on that basis, damages have been awarded to the plaintiff. And let's assume that at some point the carers of the plaintiff decide it will actually be better for the plaintiff, or it might be cheaper if the plaintiff were to be cared at home, so that the cost, instead of being $300 a day, only becomes, let's say, $100 a day. Would that mean that that the amount of damages have to be changed? And the answer is no, because as we said, damages are recovered once and for all. It doesn't have to change. And two, the courts don't have any concern how the plaintiff eventually uses the sum of money awarded to him or to her, following the case of Todorovic versus Waller. Now, one of the interesting cases we will also encounter in tort law is a situation where, in the case of Katanak versus Melcher, a plaintiff became pregnant and she gave birth to a child after the defendant doctor had performed tubal ligation, which was unsuccessful. So the defendant doctor or surgeon in performing the tubal ligation was meant to ensure that the plaintiff woman does not become pregnant, but she did. And here, on this basis, the plaintiff sued the defendant surgeon. And what the plaintiff was trying to do was to recover damages for the reasonable costs of raising and maintaining the child. And the court held that yes, the plaintiff was entitled to damages for the reasonable costs. So it's for reasonable costs of raising and maintaining the child. And the court said that in the law of negligence, damage is either physical injury to a person or property, or the suffering of a loss measurable in money terms, or the incurring of expenditure as a result of the invasion of an interest recognized by law. Now, although the court said that it's all about, suffering of a loss measurable in money terms or, expenditures, we will also know that, especially in the case of what are known as general damages, it often is difficult to actually arrive at a mathematical precision as to the amount of money that should be paid out or potentially has been sustained. And in that case, as we see, that will not be a bar to damages being awarded by the court anyway. In Katanak versus Melcher, the court also said that the relevant damage suffered by the plaintiffs is the expenditure that they have incurred or will incur in the future, or the financial damage that the parents will suffer as the result of their legal responsibility to raise the child. And the harm here is the burden of the legal and moral responsibilities which arise by reason of the birth of the child. So that's a very interesting case, right? Now, this particular law has been modified by statute, such as sections 49A and 49B in relation to failed sterilization or contraception procedures only, so that that case of Katanak versus Melcher has been modified by statute so that courts cannot award damages for the costs ordinarily associated with rearing or maintaining a child born as a result of a failed medical procedure or negligent medical advice. Now, so that there has been a change in relation to Katanak versus Melcher. Now, what would be interesting though might be those situations where a plaintiff woman might seek to recover, the costs of raising a child by herself. If, let's say, there was a man who said, I'm sterile, I'm not able to produce children, and in the process, the woman ends up giving birth. Of course, in a sense, that's covered by the rules of the Child Support Act, which is a Commonwealth law. But I mean, these are some of the types of questions that we could potentially think about. Now, there is another case of Harrington versus Stephens, and in this particular case, they're almost similar, but because it talks about a potentially unwanted pregnancy, because the plaintiff mother was saying that had she known that her child would be born with severe disabilities resulting from rubella, which had not been diagnosed by the defendant doctor, then she said she would have terminated the pregnancy. So if you follow the case of Katanak versus Melcher, the plaintiff could potentially have been successful in saying, there should be damages awarded for the costs of raising or rearing a child who has suffered severe disabilities as a failure on the part of, because the pregnancy would have been unwanted had the mother known that the child would be born with severe defects. And here, again, the High Court emphasized that it is the provision of compensation, if liability is established, that is the main function of tort law. And the court also said that the mere difficulty in the calculation of damages is not a bar to recognizing a cause of action, especially when damages conventionally awarded in personal injuries can exist. Now, however, it is in this particular case, the court said that it was not possible in the facts of this case to apply the compensatory principle because when you look at it, the comparison which is called for is a comparison between her life with disabilities and the state of non-existence in which she would have been. It is not that the comparison is difficult or problematic. It is difficult because when you think about it, the option was not really straightforward because the assertion was that the mother would have decided not to give birth to the child. In that case, there would have been a state of non-existence. So in that case, the possibility of trying to compare a situation where a child is born with severe disabilities versus a child who wouldn't have been born, to the court, that was a comparison that was difficult or problematic, even impossible. So under the principle, as I pointed out, any subsequent change of circumstances is ignored once the court has awarded a lump sum, no matter what happens. So in Lim Po Chu versus Camden and Islington Area Health Authority, the Privy Council in the UK said that the award is final. It is not susceptible to review as the future unfolds, substituting fact for estimate. So certainly, as we see, a lot of the computation towards the amount of damages that should be paid out to the plaintiff, especially in relation to general damages, where it is not possible to specifically compute what the damages should be. The courts have pointed out that a lot of the computation pertaining to general damages and non-pecuniary damages, such as loss of amenities or pain and suffering, they will involve guesswork. And even in those instances where the losses computed are pecuniary, in the sense that how much is the lost earnings, a lot of it potentially will be guesswork because you don't really know what the future will be like. Somebody may not be working today, but had it not been for the accident, that particular plaintiff may end up having work later on. Somebody may a parent, for example, may claim that my child could potentially have become a physicist or could potentially have become a judge and earn hundreds of thousands of dollars. And so a lot of this is guesswork, and we're going to be examining that scenario. What actually is it actually possible to make a claim for loss of future earnings on the basis of an assertion that a particular plaintiff could have had higher earnings had he or she not been involved in a serious accident. So, although we say that as a matter of common law, what the courts will typically do is to issue an order for the payment of an award in terms of money as a lump sum, in all jurisdictions except the Australian Capital Territory, the court may actually make a consent order for a structured settlement if the parties agree. So it doesn't have to be a lump sum that is ordered. It can be a consent order. So it's an order that is on the basis of an agreement by the parties, and the court just gives the consent. So it's a consent order for a structured settlement. So it's possible for the parties to agree that instead of a lump sum payment being made, it could be potentially periodic payments that will be made, and that will be contained in what is known as a consent order for a structured settlement. And what the structured settlement is an agreement that provides for all or part of a damages award to be paid in periodic payments funded, for example, by an annuity or other agreed means. In all seven jurisdictions other than the Australian Capital Territory, the court can only depart from the once and forever lump sum award if both parties agree to the structured settlement. Now, the effect of payment by purchase of an annuity is that the plaintiff continues to receive periodic payments from the issuer of the annuity until he or she dies. Now, let's talk of some key terminologies when it comes to damages. So there are two classifications. We talk of special damages versus general damages, pecuniary losses versus non-pecuniary losses. And these are often termed as, part of heads of damages in tort law. So special damages compensate for losses that can be proved with relative precision. So it's possible to calculate what they are. So we can talk about hospital and medical expenses between the accident and the trial. You can talk about the lost earnings or wages from the time of accident and trial. These are special damages. No problem there about computing, how much was actually lost. You can do so with relative precision. But sometimes you can't really tell. So for example, once trial is over, you can't really tell as to the kind of care that might be required to assist or rehabilitate a particular plaintiff. You don't really know what the future earnings will be of a plaintiff as a result of an injury. And so in these cases, these are losses that cannot be proved precisely. And these are what are known in tort law as general damages, and they are awarded to compensate for losses that cannot be proved precisely. Even questions about pain and suffering or loss of amenities, you can't really prove, you can't really put a particular number to, to these kinds of losses or damages. So these are considered general damages. Now, another way of classifying damages would be in the form of whether or not they're pecuniary losses or non-pecuniary losses. So in other words, it's all about in relation to money. So pecuniary losses are those that are in some way related to money. So for example, hospital medical expenses, loss of earning ability or earning capacity. These are in some way related to money because it's easily possible for you to envision what the money involved is. Now, but non-pecuniary losses are those that do not arise from expenditure of or loss of money. So for example, if somebody has lost an eye or a limb, or there is what is known as a loss of amenities because somebody is no longer able to do certain things that one potentially could have done, such as the ability to move around. A person is no longer able to do so because he might have become quadriplegic. A singer is no longer able to sing because he or she has lost her voice, or somebody is no longer able to play as a well-paid athlete because of the loss of a limb. So these are non-pecuniary losses because they do not arise from the expenditure of or loss of money, and they always form part of general damages because the value of the losses also cannot be proved precisely. So keep in mind these particular terminologies. Now, courts often divide an award of damages into components known as heads of damages. Heads of damage for ease of identification. Example, the major heads of general damages are usually, and we said when you speak of general damages, that's because you are unable to come up with a computation or estimation of what the monetary value ought to be. And so some of these major heads of general damages are usually hospital, medical, and care expenses when these occur after trial. And so therefore they cannot be proved precisely. It's different when it occurred prior to trial because you know what the specific damages would have been. But after trial, these can only be considered general damages because you don't really know the kind of hospital, medical, and care expenses that will be needed to assist or rehabilitate a particular plaintiff. Same thing with pain and suffering, deprivation or loss of amenities of life, which involves subjective feelings of loss, the inability to use legs or loss of limbs, and then the loss of earning capacity when these occur after trial, because they cannot be proved precisely, as I said, after trial, after injury and after trial, you can't really tell what the earning capacity is of a plaintiff. Will the plaintiff be able to continue to work? Will the plaintiff continue to work full-time? Will the plaintiff be able to continue to work in the same kind of profession and so on? These all involve guesswork. So it's difficult to come up with a precise calculation or computation of the monetary damages that ought to be awarded. So in that sense, they're considered general damages. The same thing with disfigurement. We need to know that the Section 51 of the Civil Liability Act 2003 Queensland has more detail about general damages and how these ought to be computed. We're not going to get to that because it's a very lengthy section and it's not really relevant for us to get into the details. We also we need to know that even when we speak of these various general damages, such as pain and suffering, deprivation or loss of amenities, and so on. They are not fixed categories, but because a lot of them actually overlap. Uh, but they are a convenient method of describing and understanding how the final award of damages is awarded, because what typically happens is, for example, among lawyers, as they try to sort out uh, if they end up negotiating to try to reach a settlement between their clients, they'd also they would attempt to try to arrive at a figure as to how much pain and suffering should be, the loss of amenities, how much is the loss of earning capacity, and so on. And oftentimes at the end of the day, because you end up with a global award, a lot of these categories become mixed up together. As far as courts are concerned, when courts do when courts do award damages, it's important for the courts to be able to clearly articulate. It's a requirement that the courts articulate the kind of heads of damages that they're looking at or awarding, and the assumptions behind each of these awards of damages. And oftentimes, because it will involve an overall and a global assessment of the monetary award, a lot of these categories often are intermixed. Okay, so let's now focus on pecuniary losses pertaining to hospital and medical and care expenses. And this is a crucial question because you want to know that when you do the computation, for example, for pecuniary losses, is it based on what is convenient, for example, for the plaintiff? Or so let's say, or what if the plaintiff says, I would prefer to be taken care of at home because I'd have my partner or I have my family members taking care of me. So is that the basis, or is it something else? So in the case, for example, of Sherman versus Evans, there was a 20-year-old plaintiff who became a quadriplegic after being injured in a motor vehicle accident driven by her fiancé, who then became the defendant. So imagine that scenario there. You're having a good time with your fiancé, about to be your husband, and then you end up in a motor vehicle accident, and then you become quadriplegic. That's pretty tragic, right? Very, very horrible. In that scenario, did the fiancé bail out? Interesting question, right? So the question there was, in terms of taking care of the plaintiff, who was only 20 years old at the time. Should it have been home care or hospital care? That question was important because that will be important as well in determining the pecuniary losses, or the amount of hospital, medical and care expenses that should be computed. And the court said that the appropriate criterion must be that such expenses as the plaintiff may reasonably incur should be recovered from the defendant. So it has to be reasonable expenses. And the touchstone of reasonableness in the case of the cost of providing nursing and medical care for the plaintiff in the future is no doubt cost matched against health benefits. It's about the health benefits to the plaintiff. The difference in relative costs is great, whereas the benefit to the plaintiff of the more expensive alternative of home care is entirely one of amenity. So here the court said that the health benefits to the plaintiff were greater if she was in hospital care, as opposed to being taken care of at home, where it was all about one of amenity or convenience or enjoyment because of the presence of family members. But having home care in no way involved physical or mental well-being of the patient. So the focus was on the health benefits, not on the amenities or comfort or convenience or enjoyment of the plaintiff. So that the court said that her life would not thereby be prolonged, nor would her physical condition be at all improved if she were to be taken care of at home. Now, but here, because, so although the court in this particular case decided to, set the award of damages on the basis of hospital care, the fact that the plaintiff was a quadriplegic would have to be taken care in the hospital would mean that her enjoyment of life would have to be diminished because, it was no longer her family members who would be taking care of her, people who love her, but it would be, doctors and nurses who are not family members. So in that case, therefore, there is a loss of enjoyment of life. And so what the court did was kind of balance it a bit by awarding, a higher amount of general damages. Okay, so, but that raises the question, if we're looking at health benefits as the criterion, according to Sherman versus Evans, for determining the type of hospital or medical care that should be given to a particular plaintiff client, would it mean that home care is foreclosed? The answer is no. Because, for example, in the case of Grimsey versus Southern Regional Health Board, here, the plaintiff, which was a case in Tasmania, the plaintiff was awarded damages for home care, including the cost of building a specially designed home in which her needs could be cared for. The reason for that was that the court felt or arrived at a decision that there were more significant health advantages to the patient or to the plaintiff being taken care of in the home, rather than in a hospital. So now, the other question is, assuming that, following the case of Sherman versus Evans, assuming that an award of damages has been made, and the assumption of the court was that, hospital care was more beneficial in terms of health to the plaintiff, and so awarded damages on that basis. What happens then if, after receiving the award of damages, which would have been higher because it might have been more expensive if it were in the hospital, what if then the plaintiff or the plaintiff's relatives decide that the patient should then be taken care of in the house, for example, to reduce costs? Would that be permitted? And the answer is yes, because under the once and forever principle, enunciated in Todorovich versus Waller, the court has no concern with the manner in which the plaintiff uses the sum awarded to a plaintiff. So once it's paid out, that's the end of the story. It's up to the plaintiff or the plaintiff's family members to decide what to do with the monetary award. Now, one other interesting or important issue pertains to gratuitous services, or services which are provided for free. It can typically happen that, for example, in a home care setting, when somebody is injured, it will be a family member who takes care of the injured plaintiff. The question is, should the court consider the cost of gratuitous services? And this is what is known as the Griffiths versus Kirk-Mayer damages. And these are damages in relation to gratuitous services provided. In this particular case, the plaintiff required constant nursing care for the rest of his life after a catastrophic injury. And nursing care would be gratuitously provided by plaintiff's fiancé and family. Imagine that. So, there's that goodness in a lot of human beings still. So somebody had, required to be taken care of. In this particular case, the plaintiff's fiancé did not bail out, but was willing to take care of the injured victim. So should the hospital and care expenses be discounted? But the court said that the plaintiff's relevant loss is his incapacity to look after himself, as demonstrated by the need for nursing services. And this loss is to be quantified by reference to the value or cost of providing those services. So yes, even though the services were free, were gratuitously provided, they should be counted as part of hospital and care expenses. So the court said that the fact that a relative or stranger to the proceedings is or may be prepared to provide the services gratuitously is not a circumstance which accrues to the advantage of the defendant. So the gratuitous services have to be included in computing for the pecuniary losses that should be awarded to the plaintiff. Now, the other point was, does the plaintiff have to prove the actual cost of having the caring services provided, or by reference to the income foregone by the service provider? So how do you compute for the gratuitous damages? In this same case, the court said that once it is recognized that it is the need for services which gives the plaintiff the right to an award of damages, it follows that the damages which he or she receives are not determined by reference to the actual cost to the plaintiff of having them provided or by reference to the income foregone by the provider of the services, because the market cost, so it is the market cost of services which ordinarily is the reasonable and objective value of the need for those services. So it is the market cost, which as a general rule is the amount which the defendant must pay as damages. So it's in relation to the market cost of providing those particular services. The other question that we ask is, what happens to a situation where it might be the defendant himself or herself who is actually liable for the damages to the plaintiff? So imagine a scenario where you have a husband who was driving the vehicle, and out of negligence, the husband has an accident which then leads to injury suffered by the wife, who is the plaintiff. And if in the process, what if the husband then, as the defendant, then takes care of the wife? Should the gratuitous services then be discounted? After all, the defendant himself was responsible for the injuries to the plaintiff. And the answer is, in that particular case, the gratuitous damages, the Griffiths versus Kirkemeyer damages or the gratuitous damages will still be awarded. Okay, and then a case for that would be Cars versus Cars. However, the issue about the concept of Griffiths versus Kirkemeyer damages has actually been modified by most of the state jurisdictions in Australia. For example, under Section 59 of the Civil Liability Act 2003, Queensland, Kirkemeyer damages cannot be awarded, meaning gratuitous damages cannot be awarded unless the services are necessary and the need for the services arise solely out of the injury in relation to which damages are awarded, and the services are provided or are to be provided for at least 6 hours per week and for at least 6 months. So the point there, so for example, you have a situation where a parent has been taking care of a child. The child then becomes seriously injured in an accident. The question is, under Section 59 of the Civil Liability Act, can Griffiths versus Kirkemeyer damages be awarded? So let's assume that the parent has nothing to do with the negligence action. You've got a parent taking care of a young child. The child then gets hurt. So certainly, because the parent has been taking care of the child, the parent will continue all the more to take care of an injured child. So would those gratuitous or free services by a parent then be computed or calculated following Section 59? The answer is no, because in that particular case, the services had already been there, had always been there, would have been provided regardless of the injury. So following the Griffiths versus Kirkemeyer damages, the rule under Section 59, Griffiths versus Kirkemeyer damages cannot be awarded. So no damages would be recoverable for value of care provided by a parent to an injured child if the parent had always been providing those services to the child anyway. Now it's different, for example, if you've got a parent and an adult child. The parent hadn't been taking care of the adult child, and then because of the injury, the parent now has to take care of his adult child. In that case, Section 59 will not apply because the need for services on the part of the parent arose solely out of the injury in relation to which damages were awarded. The parent in the second scenario wouldn't have been taking care of the adult child, but the adult parent in the second scenario is only taking care of the adult child as a result of the injury. So in that case, Section 59 does not apply. Griffiths versus Kirkemeyer damages would still be payable. In Clement versus Bacco, this was a situation where the plaintiff had been working in his own land as a commercial timber plantation. In Oland, which was a commercial timber plantation, there was an accident. As a result, the wife then performed those duties. So in this case, the wife wasn't taking the Kirkemeyer damages wasn't about the wife taking care of the husband. It was about the wife now having to perform duties which the plaintiff used to do when he was not injured. So the question was, since the wife is now, performing these duties and they are free because she is not getting paid, the question is, would the liability, would the limitations under Section 59 of the Civil Liability Act apply? But the court said that damages should be awarded in respect of the plaintiff's wife's gratuitous services in the timber plantation, because we know that the only reason that the services are necessary for the commercial timber plantation, but secondly, the gratuitous services of the wife arose only because of the injuries to the husband. She wouldn't have done it were it not for the fact that her husband would no longer do it. In CSR Limited versus Eddie, the plaintiff had developed mesothelioma, kind of a lung cancer, from being exposed to asbestos dust in his workplace. Should damages include the plaintiff's loss of capacity to care for his disabled wife? So here, the plaintiff used to care for his disabled wife. Now he couldn't do it. So should there be, Kirkemeyer damage, Griffiths versus Kirkemeyer damages in relation to the disabled wife, who wasn't the one, involved in the negligent accident, considering that the husband is now unable to take care of his disabled wife? And the court said that no, damages for loss of plaintiff's ability to care for his wife should not be awarded. Because remember, as far as Griffiths versus Kirkemeyer damages are concerned, the purpose there is really to compensate the plaintiff for the losses. Here, it's, in this scenario where the plaintiff had lost the capacity to care for his disabled wife, the focus in that sense would now be taking care of the wife, which is not the contemplation of the common law. So the court said that Griffiths versus Kirkemeyer damages are awarded to plaintiffs to compensate them for the cost, whether actually incurred or not, of services rendered to them because of their incapacity to render them to themselves, not to compensate them for the cost of services which, because of their incapacity, they cannot render to others. We also read, however, that in limited circumstances, an award of damages for the loss of the ability to provide gratuitous domestic services may be allowed if the requirements of Sections 59A and B of the Civil Liability Act 2003, Queensland, are met. So we're not going to get into that because these are very long provisions of law and are not really that important. So we've covered so far the once and forever principle. We've talked that as a matter of law, as a matter of common law, payments are done as a lump sum, although periodic payments may be permitted if there is an agreement that is entered into the parties and that is embodied in a consent order that is then issued by the court. We also said that courts are not interested really in, once an award of damages is given, it's not interested in knowing, how the award of damages has been used, or if there has been a change in the kind of care or hospital services that are then given to assist a patient. Courts are not interested in that. Now, so the question, we now go to the point about, is it relevant to find out if the plaintiff has a job? Is it relevant to find out how much the plaintiff is earning? When I started this lecture video, I had talked about a scenario where you might have two plaintiffs who suffer separate accidents. Let's assume that the accidents are exactly similar, same car, different dates, okay, different places, same car, same horrific injuries, both become quadriplegic. Assuming the same negligence scenario, okay? So we're clear. Let's assume that, that's the scenario. The question is, would the amount of damages matter depending on who the plaintiff is? Assuming, so in other words, if you have the same kind of tortuous incident, does the plaintiff's attributes matter, or the kind of earnings that the plaintiff has? Would his wealth matter? The answer is yes. And this is important, as we see in a short while. This is a very important point because, again, in relation to the no-win, no-fee arrangements that some law firms are able to provide, they always ask the question, how much is the plaintiff earning? Because if the plaintiff is not earning a lot of money or has not been working, then the law firm may not be very enthusiastic in undertaking legal representation for the plaintiff, because the amount of earnings of a plaintiff client do matter in terms of the award of damages that will be given, because of what is known as the loss of earnings, which are computed in relation to an award of damages. So one of the important damages that can be awarded is the loss of earning capacity. So in relation to the loss of earning capacity, the court compares a plaintiff's pre-accident earning capacity with his or her post-accident earning capacity. There often will be a difference. One, because prior to the accident, the plaintiff might have been working full-time. Prior to the accident, the plaintiff might be able to do certain types of work. But because of the accident, maybe the loss of limb, the loss of vision, becoming a quadriplegic, or suffering from depression or PTSD or some other difficult psychiatric condition, the plaintiff can only work part-time or work in particular scenarios, which would mean there is a change in the earning capacity. The courts would then award damages to represent the difference between the pre-accident earning capacity and the post-accident earning capacity. Because what typically happens is that, as we know, after an injury, the plaintiffs generally earn less after an accident because of a diminished physical and mental capacity. As well, when we speak of loss of earning capacity in Wine versus New South Wales Insurance Ministerial Corporation, the High Court said that there should also be a discount for contingencies or vicissitudes to take account of matters which might otherwise adversely affect earning capacity. So positive considerations which might have resulted in advancement and increased earnings are also to be taken into account. Contingencies are to be considered as well in terms of their likely impact on the earning capacity of the person who has been injured, not by reference to the workforce generally. So there is some kind of a guesswork involved as well, because when you look towards the future and trying to compute for future lost, when you try to compute for lost future earnings, you don't really know what will happen in the future, because the future is uncertain or unknown. So the courts have to try to provide a discount for contingencies or vicissitudes. Now, what plaintiffs typically do then is that if they were, if they had an accident involving the tort of negligence, the plaintiffs will try to prove that they are no longer able to work. So if they were working, they will now say that I'm no longer able to work, so you have to compensate me for my inability to work. Or they will say that I could have earned more had it not been for the injury. So the question is, how much more should be awarded to compensate for the loss of earning capacity? What we often need to know as well is that when you look at the cases pertaining to tort, a lot of them don't end up going to court, at least not an action for tort, but a lot of them actually involves criminal behavior that is often in the news, where somebody who is involved in an accident will then fake the extent of the injuries or harm. For example, whiplash injury resulting in a neck problem or a back problem and so on. Some will say that they're no longer able to work. And what then happens is that if this involves an insurance company as a defendant, the defendant insurance company will then hire investigators, private investigators, to determine if the allegation or the claim of a plaintiff that he could no longer work, he could no longer walk properly, he could no longer do this or that is true. And in some scenarios, it has been shown, for example, that somebody said, oh, I've got a back injury, I'm no longer able to move. Then it turns out that this particular plaintiff continues to play basketball. It's been in the news. Not only would that impact on the ability to claim damages, but also it can lead to fraud, which is a criminal offense. Now, I was talking earlier about somebody I know who had been involved in a workplace accident. And in order to be able to claim a higher amount of damages to show that, there was so much pain and suffering, loss of amenities, and so on, this person I know stayed at home for about 2 to 3 years, pretending, I know because I talked to him, pretending to suffer severe depression. He never stayed out. He grew a very long hair. When he would go, no, he did go out sometimes, but when he did go out, he'd appear like he was severely depressed, like he wanted to kill himself. But actually, it was all an act. And I said, "How did you do it?" And he said, "Oh, because for a while I was actually part of a drama club, so it was all an act. But because of that, he was able to buy at the age of about early 30s. He had his own brand new house. He bought 2 cars. He bought a jet ski and so on. So yeah, it paid off for him. And certainly, once this did go to court, the insurance, he was paid about $1 million in damages, I think, by workplace compensation. But once it had been paid, after about 3 or 4 months, he was okay, living the good life, right? So anyway, that's tort law for you. Now, there, as I mentioned as well, in almost all jurisdictions in Australia, the courts have, the state parliaments have put a cap to the amount of damages that could be awarded for loss of earning. So, for example, under Section 54 of the Civil Liability Act 2003, Queensland, it says that in making an award for damages for loss of earnings, including in a dependency claim, the maximum award a court may make is for an amount equal to the limit fixed by subsection 2. So there is a maximum award. Now, what is the limit? The limit under Section 2 is that it is an amount equal to the present value of 3 times average weekly earnings per week for each week with a period of loss of earnings. In this section, present value means the value when the award is made. Now, I've actually read the case of Toohey versus Freemasons Hospital, which is a long case. This involved an engineer who was earning about $10,000 a week. Can you imagine the kind of income? And the question then is, there was definitely a change then in the kind of income. The question for the court was, how do you compute for loss of earnings? I wish I could try to explain that to you guys. I went through the case. I couldn't quite explain how to do the computation. So you're gonna have to forgive me. That was probably the reason why I took up law. I had difficulties with math. So, but don't worry, I'm not going to be asking you to do a computation anyway. But we do know that under Section 54, there's a limit in the amount of damages for loss of earning. So again, remember that in the case of Todorovic versus Waller, in terms of trying to determine the cost of the loss of earning capacity, the court compares the plaintiff's pre-accident earning capacity with his post-accident earning capacity, and the damages are awarded to represent the difference between the two. Now, what happens when earnings cannot be precisely calculated? And this is provided as well in Section 55 of the Civil Liability Act. So it says there that this section applies if a court is considering making an award of damages for loss of earnings that are unable to be precisely calculated by reference to defined weekly loss. The court may only award damages if it is satisfied that the person has suffered or will suffer loss having regard to the person's age, work history, actual loss of earnings, etc. So the point there is that the court cannot just willy-nilly award damages. The court must be satisfied, and this must be shown in the decision there, that the court was satisfied that the person has suffered or will suffer loss. So although there is discretion, it must be discretion based on a satisfaction by the court, a finding by the court that the person has suffered or will suffer certain damages. If the court awards damages, the court must state the assumptions on which the award is based and the methodology it used to arrive at the award. So there's a requirement on the part of the court that if the court awards damages, depending on the heads of damages that we talked about, pecuniary losses, non-pecuniary losses, specific damages versus general damages, the court must state the assumptions the court can't just, award damages without being to state what its assumptions are or being able to be satisfied that the person has in fact suffered. So the limitation mentioned in section 54.2 applies on award of damages under this section. But this section only applies to awards of damages made by the courts. In other state jurisdictions, you could have a tort award done by a jury. That wouldn't apply because the jury wouldn't be required to be satisfied about the suffering or state their assumptions. The jury will probably just say, this is the award of damages as an overall or global assessment that ought to be given to the plaintiff. Now, what happens to instances where the plaintiff is not earning or is under earning at the time of the accident? In other words, you can have people where, for a variety of reasons, they're not working at that time. Maybe because they're taking care of somebody, or maybe at that time they decided to work less. What happens? So you have many plaintiffs have future earning capacity when they're injured, but they are not using that capacity to its fullest when it is diminished by the defendant's negligence. So in this situation, it is often difficult for the court to determine what the plaintiff either would or could have earned in the future, but for the injury, right? Because you can't really tell what the future would be like. So a parent, for example, would say, oh yes, my son isn't working right now, but he could have been a heart specialist earning $240,000 a year. So in that case, what courts often do is what they award what is known as a buffer damages for loss of earning capacity. Now, in White versus Redding, the Court of New South Wales said that when it comes to, for example, the earning capacity of an injured child, you'd have to describe the principles as an exercise in estimation of possibilities. It's about possibilities, some kind of guesswork, not proof of probabilities, that sometimes involve guesswork rather than an estimation. So because you just can't tell what the future is like. Now, just as difficult to know what the plaintiff would as opposed to could have earned if the plaintiff is an adult who is unemployed when injured. So in such cases, the court usually does award damages on the basis that the plaintiff has lost some capacity to earn in the future, but the awards are typically small because they do, remember, as far as compensation for tortuous injuries or damages are concerned, it's based on the pre-accident earnings as compared to future earnings or lost earnings. So if you have a plaintiff who is unemployed when injured, there can still be an award for damages for future lost earnings, but typically the awards will have to be small because it's difficult for the court to think that somebody who is unemployed today will suddenly earn $500,000 every year, because that person then becomes potentially a barrister or a vice chancellor of a university. So in the case, for example, of Royal Dental Hospital of Melbourne versus Akbalut, the Victorian Court of Appeal overturned substantial damages which were awarded by a trial judge, as there was insufficient evidence to support valuation of a plaintiff's earning capacity as a singer. In Mann versus Elburn, the plaintiff was employed as a stenographer, but was only working about 2/3 of total capacity because of other commitments. Here, the court said that damages should be assessed on the basis of loss of the earning capacity that the plaintiff was exercising at the time of the accident and would have continued to exercise but for the accident. In this case, because the plaintiff was only working 2/3 of total capacity, that then was the basis for the computation of the loss of earning capacity in the future. And then plus a component to represent the loss of chance of exercising her capacity in full at some time in the future. But then that component will have to be small. And this kind of calculation, calculating loss, was approved by the High Court in the case of Medlin versus State Government Insurance Commission. So we've talked about loss of earnings. which is a pecuniary loss. We're now talking of non-pecuniary losses, or what is typically known as the loss of amenity and disfigurement. These can often be separated. You can have loss of amenity from a variety of reasons. You can also have disfigurement. Now, disfigurement itself can also lead to a loss of amenity. As we said, when we speak of loss of amenity, it's simply the inability of an individual to function like he used to. So he loses certain convenience, certain comfort, certain abilities, certain capacities. So that is a loss of amenity. The award of damages for loss of amenity is designed to compensate for loss or continuing disability so far as money can do so. So a court takes into account the extent to which the plaintiff has subjective feelings of loss. So you're most likely to experience a subjective feeling of loss, right? Because there are certain things you can no longer do. So for example, a plaintiff who enjoyed playing sports before the accident may receive more for loss of a leg than a plaintiff who led a sedentary exercise because the loss of the limb means more to the former plaintiff than to the latter. So somebody has been playing a professional basketball player, for example, who can no longer run because of the loss of a limb out of a car accident, is likely going to be paid higher in terms of damages for loss of amenity. Now, note though that the loss of amenity is about subjective feelings of loss, subjective feelings from the viewpoint of the plaintiff. So what happens where the plaintiff is comatose because of the accident? So because the person is comatose, it's difficult to say that there are subjective feelings of loss, right? He's unaware, he's comatose, in coma. And the other relevant question is, if you lose a limb, how much is the loss worth? How is that computed? Now, when we speak of non-pecuniary losses, these are losses that do not arise from expenditure of or loss of money. They always form part of general damages because they can't really be proven precisely. You have certain heads of damages there: loss of amenity, disfigurement, pain and suffering, and loss of expectation of life. So we're going to go through them here in the next few slides. So again, the loss of amenity is, as I mentioned, it's to compensate the plaintiff for any continuing disability that he suffered as a result of the injuries caused by a defendant. So in Skelton versus Collins, for example, what had happened here was that the plaintiff was unconscious, permanently unconscious or comatose. How do you compute for the subjective element, or do you compute even for the subjective element for the purpose of assessing the proper amount of damages in relation to loss of amenity? And the High Court said that in assessing damages for a loss of the amenities of life resulting from the physical destruction or impairment of some part of the body, I find it impossible to ignore the subjective element. So the subjective element is important, certainly for computing loss of amenity. The expression loss of the amenities of life is a loose expression, but as a head of damages in personal injury cases, it is intended to denote a loss of the capacity of the injured person consciously to enjoy life to the full, as apart from his injury, he might have done. But in this particular case, the plaintiff was permanently unconscious. So because he was permanently unconscious, the subjective loss would likely have to be less, right? He couldn't even perceive any subjective feelings of loss because he was unconscious, he was comatose. So the court awarded only a small sum for loss of amenities, even though objectively the plaintiff was rendered quadriplegic because the plaintiff, given his permanent unconscious state, would have been unable to really suffer subjective feelings of loss. Now, this particular principle about subjective feelings of loss was further examined in the case of Namala versus Northern Territory, where you had an Aboriginal woman who sought compensation for the loss of fertility from a negligently performed hysterectomy. And the court said that when you speak of, when you compute for loss of amenity, some of the factors that are taken into account include the plaintiff's subjective suffering, as well as the aggravation of the plaintiff's subjective suffering by virtue of the cultural importance of having a large number of children. So that's part of the subjective suffering as well. And the plaintiff's subjective suffering resulting from a loss of cultural fulfillment. So these are some of the factors taken into account when you speak of subjective feelings of loss and loss of amenity. The amenity may be awarded if the plaintiff, even if the plaintiff is scarred as a result of the accident. That would be a separate head of damage, such as disfigurement or cosmetic disability. Now, in Manning versus New South Wales, this is different as well, because here, objectively, there were serious injuries. But the question is, as a result of the very serious injuries, which included brain damage, how do you account for subjective feelings of loss? So here, although the plaintiff's injuries were very severe, there was little or no subjective appreciation of his loss of amenity because of the extent of the injuries. That was the claim of the defendant. But the court said that both subjective and objective matters have to be taken into consideration as well in relation to loss of amenity. It's not just subjective feelings of loss, you also have to look into objective matters. So here the court said, I am not persuaded that an assessment of non-economic loss is essentially a subjective exercise, and that objective consideration should be given only minimal weight. The court said that here the plaintiff suffered major and significant injuries in an objective sense, but that he has some appreciation, albeit not a complete appreciation of his injuries and what he has lost. So therefore, he was entitled to a non-economic loss at 80% of a most extreme case. So it wasn't here just a question of looking at the subjective feelings of loss, but also considering objective matters involved, such as the extent of the injuries. So we've talked about loss of earnings, we've talked about loss of amenities. Let's talk about pain and suffering. So it's one thing to talk about loss of amenities and the inability to do certain things, but in many cases, a lot of the plaintiffs also undergo pain and suffering. So the court says that there should be compensation for the pain and suffering that the plaintiff has felt and will feel as a result of the accident, and damages are entirely subjective. What is often difficult here, in the case of loss of amenities, for example, although it's difficult to arrive at a specific mathematical computation as to the amount of loss, because it's subjective, but you do get a sense of what it's probably like, right? When you can no longer walk, you can no longer talk, you cannot see, and so on. You get a sense. But when it comes to pain and suffering, how exactly does a judge know, or even how does a medical professional, medical expert determine the level of pain or suffering other than through the self-report or the claim made by a patient? In other words, there's a lot of room there, scope there for plaintiffs to fake the level of pain and the level of suffering that they are undergoing. And note, but because they are entirely subjective, a lot of it depends on the ability or inability of a plaintiff to demonstrate or show pain and suffering. So, but the court said in Skelton versus Collins that where the plaintiff was permanently unconscious, it's possible he will not be able to experience pain and suffering. So in that case, no damages would be awarded to a permanently unconscious plaintiff. The court said, if a plaintiff's condition as a result of his injuries is such that he is insensible to physical pain and suffering, it would be inappropriate to award damages under this head. The reason for this being simply that a plaintiff in such a condition does not experience pain and consequently does not suffer on that account. Now, I wonder if that, that's the legal rule, right? But is that really true? Is it really true that people who are unconscious cannot experience pain? Because we do have come across, maybe that's a problem, that's a fault on the part of the medical expert there. Because we do have instances where somebody says he is unconscious, but is fully aware that he cannot talk. And so therefore there's pain and suffering there. Haven't there been instances like that? You it's like you're comatose, you're not really conscious, meaning when people look at you as a patient, you are unconscious, but there's actually an awareness on the part of the patient of what appears to be going on. And in those states, for those who are in coma for quite some time, there have been stories where the patient feels trapped in that comatose body, but is aware of the suffering. And there's suffering and pain involved. So anyway, but that's a ruling in Skelton versus Collins. It may change at some future time when the court is able to maybe realize that there is still pain and suffering on the part of somebody who is in fact unconscious. Now, and remember, what the other rule is that as far as pain and suffering is concerned, it is not intended to compensate for loss of earnings or earning capacity, which is a separate head of category, head of damages altogether. Now, in relation to head of pain and suffering, the assessment of damages must be founded on the evidence, even if it is an imprecise head of damage. Remember, it's subjective. So again, the expert evidence and the personal evidence provided by a plaintiff as to the kind of pain and suffering that he or she is undergoing would be crucial. Because again, when a patient is saying, you know, it's really painful, I can't walk, I can't do this, I can't do that, a doctor, there is no medical device that would enable anyone to actually know the level of pain or suffering, because it's very subjective. So who the plaintiff is, the ability of the patient to fake it would actually be crucial. No, that's not the proper way to do it. So the ability of a plaintiff to properly testify as to the kind of pain and suffering that he or she is experiencing would be crucial. I'm not saying that that's necessarily faked, okay? So that's not what I'm saying. Now, the case of Government Insurance Office, New South Wales versus Best, in this case, the trial judge based the assessment of pain and suffering on common human experience. And so here the judge was saying that the plaintiff's grief at her husband's death would have faded with time. And because the plaintiff was still depressed, then the judge was saying the depression was mainly a consequence of her own injuries. So in this particular case, the defendant appealed because, you know, the defendant was saying there was no basis for an award for pain and suffering for depression, because the defendant was saying the depression was likely not because of her own injuries, but actually because of the grief at her husband's death, which is not compensable, because remember, it's compensation for loss to the plaintiff himself or herself. And so here, the appeals court said that it was not open to the trial judge to act on what he described as common human experience in respect of grief-caused depression in this case, primarily because the evidence from the psychiatrists provided no support for that conclusion. So there had to be evidence that was proffered by a medical expert in that area. And then we talk about loss of expectation of life. You would often, you know, expect to live long, right? We all hope that we live up to the age of, I don't know, 85, 90, 95, even 100 perhaps. Now, if the plaintiff's life has been shortened, he or she is then awarded to compensate for the loss of life of expectancy. So it's the expectancy that you live longer, but now because the life is shortened, there is a payment for that. But Justices Gibbs and Stephen in Charman versus Emmons described the award of damages for loss of expectation of life as curious and unsatisfactory, mainly because when you think about it, when you talk about loss of expectation of life, you do assess this as well in relation to loss of amenities and even pain and suffering. So they found it curious to be thinking about, you know, as a separate head of damage, loss of expectation of life. In some jurisdictions, a separate consideration of this head is only necessary in those jurisdictions that have not adopted a holistic scale method of assessing damages for non-pecuniary loss, as New South Wales, South Australia, and Queensland have. So because in general, when it comes to a method of assessing damages, which can be important in terms of negotiating between the lawyers and the parties as to the amount of damages to be paid, loss of expectation of life often comes into the picture in an assessment of a global amount of damages to be paid by the defendant. Now, finally, let's talk about aggravated and punitive exemplary damages. Again, as I pointed out, especially in the US, the amount of aggravated and punitive or exemplary damages would often be very high. One as a way of deterring future abhorrent behavior, or as a way of, punishing the defendant. So even if the injury may be small, but if it were done in circumstances which are really egregious, then it can be the punitive damages which are higher. So the loss of earning capacity might just be for $100,000, and then in the US, punitive damages might be $10 million. So that's the way it is in tort law in the US. That is not the case in Australia. So we need to know that aggravated damages are a special form of compensatory damages. They're intended to compensate for injury to the plaintiff's feelings caused by conduct of the defendant that goes beyond ordinary wrongdoing of a kind consistent with ordinary human fallibility. So if the negligence or the wrongdoing was ordinary, based on ordinary human fallibility, you shouldn't be thinking of aggravated or punitive or exemplary damages. That there should be no compensation for that. So punitive damages, also known as exemplary damages, are awarded to punish the defendant and to deter repetition of the tortuous conduct. It is also awarded only if the defendant is guilty of a conscious and contumelious disregard of the plaintiff's rights. Okay, now, the rule on aggravated and punitive damages have actually been, has been modified in Queensland. For example, in Queensland, under Section 52 of the Civil Liability Act, it can only be awarded if the act that caused the personal injury was an unlawful intentional act done with intent to cause personal injury, or was an unlawful sexual conduct or other unlawful sexual misconduct. In other instances, aggravated and punitive damages cannot be awarded except in these three categories. So, at the end of this module, students should be able to describe the different types of damages available in tort, explain the common law principles governing the award of damages in appropriate cases, explain how heads of damage are used to calculate an order of damages will apply to specific fact scenarios, and discuss the impact of the Civil Liability Act 2003, Queensland of damages for personal injuries. And with that, thank you for watching this video, and I hope to see you soon. Bye.